Greetings, my fellow freedom loving sovereign thinkers. Thank you for tuning into LL3 Podcast. My name is Craig, transmitting from the beautiful swampy Mango, South Florida. And today's date is Saturday, January 18th, 2020. Woo! So there's going to be some big rally happening in Richmond, Virginia. And plus, during that, before that, it looks like there was a executive state of emergency trying to discourage people from going because Governor Northam and his lackeys are nothing more than treasonous parasites. One of the areas you gotta start looking at is they are proud oath breakers and they make themselves less patriotic than Benedict Arnold. That is right. And they're just examples. We got all these forms of jugheads all around the country, whether it's federal, state, or local. We're all keeping our eyes out in Virginia. We got to focus on your own states as well, including Florida. Because I'm ready to call those bastards out, too. Well, one great thing's happening that West Virginia is going to have a referendum to nullify all federal gun laws, past, present, and future. And that will drive Washington, D.C. crazy. And they're actually going by the 10th Amendment and Federalist Papers 46 by James Madison. They don't have to cooperate with the feds. And remember, any repugnant to our U.S. Constitution is void, including the states as well. And of course, you got looks like the Supreme Court may be talking to them about doing an opinion on the Electoral College. Please give me a break. You want to support judicial supremacy? Forget about it. I don't care about their damn opinions. That's all it is, folks. All you gotta do is read the Constitution. It's self-explanatory. But whoa, we gotta go to the Supreme Court. Come on. How irrelevant is that? Because the true bottom line is this. The national popular vote was a form of centralization. I support these United States, not the centralized United States. Or centralized states of America. Well, because President Trump won by Electoral College and Hillary Clinton won the popular vote and people are ranting and raving, give me a break. You always got to focus on one thing about the president's job. Article 2 of that federal enactment, the Supreme Enactment. The president's supposed to be an elected ambassador represented by the states. They had a discussion about popular votes in the Constitutional Convention. They found that very dangerous. The small states can't put their 2 cents in and be more deprived. You want that? I don't. I don't want 4 states telling me who's going to be my next president. That's pathetic and illegal and unacceptable. Bottom line is this, folks. The president is an elected ambassador, not our Lord and Savior. Everyone's complaining about Trump this, Trump that. Don't get me wrong. I'm critical of him on his decision making. And many people in his cabinet I am not impressed with. Our rights are natural born. We have natural rights. It's not written by man. I don't care if you believe in God or not. It doesn't bother me. It doesn't make a difference. We have it in our system, in our blood, of being free-thinking individuals. Not numbered, not owned by the state. They believe, well, they say so. Come on. It doesn't work like that. It's ironic because, going back to Virginia, it's happening on the observance of Martin Luther King's birthday. Some people claim to be a communist. Well, you gotta look at all sides to the story. You gotta be vigilant to anyone that speaks their mind. And observe things a lot more thoroughly. Doesn't matter where you come from, what your faith is, and what you look like. Our rights are natural. We were born with them. Don't let these saps tell you any different. Yes, I do denounce as the United States of America being a federal corporation. Title 3002, Title 28, U.S. Code 3002, subsection 15. And I do condemn the 1871 Reconstruction Act. Enough said on these matters. A lot of crazy stuff is happening, but a lot of great things are going as well. Best thing to do, my friends, teach. Be the rabbi, be the teacher. Share information with folks. Don't let TV tell you any difference from mainstream garbage bobbleheads. Whether it's left or right, it doesn't matter. They think alike and smell the same, and their rhetoric is totally lame. So, without further ado, interesting thing here I'm going to focus on came from the gatewaypundit.com. Is exclusive. General Flynn's first law firm hired deep state attorney. That'll be the name of the title. Of course, a plus. So, look at the one title. If it's a plus, there's more than just one area. So, don't be shy. At the same time, they were repping Flynn. Did they share the Flynn this conflict of interest? As it reads here, General Flynn's first set of attorneys were from the firm Covington. The DOJ's Tricia Anderson went to work for Flynn's attorney law firm while they were repping for General Flynn. Did Covington tell General Flynn about hiring one of the individuals at the DOJ involved in the Russia collusion sham? You still got folks out there buying that garbage? Are they actually inspired or hired? If they're inspired, you gotta laugh at them. Like, hi, I'm an obtusaholic. Yeah, Obtusaholic Anonymous. Okay, I'll keep on going here. Tricia is a member of Covington as a partner and joined the firm in September of 2018. Here's a nice little profile of her. Continue on here. Anderson was deep in the deep state at the FBI that worked on the coup attempt of President Trump. Epoch Times reported this on Anderson's testimony in front of Congress only a month before she left for Covington. A key player in the FBI's counterintelligence investigation of Donald Trump and his 2016 presidential campaign was Tricia Anderson, who at the time was the number 2 lawyer at the agency's office of General Counsel. Despite having no specific experience in counterintelligence before coming to the FBI, Anderson was in some manner involved in virtually all of the significant events of the investigation. Anderson told members of the House Judiciary and Oversight Committees in August last year during the closed-door testimony that she was one of only about 10 people who had known about the Trump-Russia investigation prior to its official opening. A transcript of Anderson's testimony, which was reviewed for this article, revealed that she had read all of the FBI's FD 302 forms detailing information that the author of the Steele dossier, former British spy Christopher Steele, had provided to high-ranking Department of Justice official Bruce Orr. Anderson also took lawmakers that she personally signed off on the original application for a warrant to spy on former Trump campaign advisor Carter Page without having it read it. The FBI relied heavily on the unverified information in the Steele dossier, which was paid for the Clinton campaign and the Democratic National Committee obtained to the FISA warrant. Anderson also was part of a small group of FBI personnel who got to read then FBI Director James Comey's memos about conversations he had with President Trump. Covington, who also represented General Michael Flynn at the time that Anderson was hired. This indicates a conflict of interest for the firm, and the question is whether General Flynn was ever notified of Anderson's hiring. In the legal field, one of the legal duties every lawyer must observe is to avoid conflicts of interest when it comes to their clients. In fact, if a lawyer represents a client knowing that there's a conflict of interest, they can be disciplined by the state bar and sued by the client for legal malpractice. And there is a list, types of attorney conflicts of interest. And it's in the link that goes to findlaw.com. You can look for yourself. Very interesting stuff, folks. There are a variety of conflicts of interest that can prevent a lawyer from taking on a particular case. The conflict may occur between the prospective client and one of the attorney's current or former clients. There can also be concerns if a client's interests are in conflict with the lawyer's professional or personal relationships. For example, if the client is looking to sue a particular business that happens to be owned by the lawyer's brother-in-law, there is a conflict of interest for the attorney. It's also possible for there to be an issue if the potential client's interests are at odds with the attorney's own interests. A conflict of interest can also occur at the law firm level. For example, even if an attorney working at the law firm didn't personally work on a particular matter because someone else at the firm handled it. If the attorney leaves the firm, he or she could still have a conflict of interest related to that matter based on the firm's work. Covington is currently already in hot water for representing General Flynn and not recusing himself earlier. According to the Federalist, retired Lieutenant General Michael Flynn faces the real possibility of jail time when he is sentenced at the end of this month in connection with the guilty plea he entered in 2017. But that plea appears to be tainted because his original lawyers had conflict of interest that arose in their involvement in one of the offenses folded into the plea. The fallout from that conflict of interest appears to have created Flynn's current predicament. Robert Mueller's Office of Special Counsel investigated Flynn for potential criminal charges that included one, lying to the FBI about his conversation with the Russian ambassador, where he was part of the President Donald Trump's national security transition team, and two, making a false statement in his filings under Foreign Agents Registration Act, FARA, for work he had allegedly done for the government of Turkey prior to the November 8, 2016 election. Covington and Burling, LLP, a prominent law firm, represented Flynn in the investigation and in plea negotiations. The firm also assisted him in preparing the allegedly false FARA filings. Interesting there. Michael Flynn was targeted for his FARA filing. Covington had a conflict in representing him since they assisted him in creating the FARA application in question. Well. Looks like this man may have been entrapped himself. Was General Flynn advised of the situation and or did he give his permission to proceed regardless? Is this another perceived, if not actual, conflict of interest Covington made? That's a legitimate question there. And it's funny, it looks like he may have entrapped himself. Larry Flynn, I could say he was only a patsy. Now he needs a partial judge. This current one is a deep state stooge. Yes, of course. So, and if you go to Newsbuzz, Newsbuzz talked about this, and it was very inaccurate what happened with Michael Flynn. But remember one thing, those bastards in Washington, D.C., the globalist Uncle Toms and Angel Mounds, I say that ethically once again, don't give a damn, because they're making business. But if he does, if someone else does it from the outside, it's a no-no. Exceptionalism is patriotic. Something to look at, my friends. So, find it very disturbing indeed, but they got some real good comments in here. But the fact is, corruption is a lot deeper than what people think. But hope for the best for Mr. Flynn, because I do see him as a patsy here. And so, speaking of Virginia, Richmond, Virginia, the CaptainsJournal.com brought this out to light. Special Operations Surveillance Aircraft Circling Richmond is by Herschel Smith. At this hour, there's a USAF U-28 aircraft circling the Capitol. It came out today, and of course, this is what Mr. Chapman has to say about it. If blackface Northam can negate the Second Amendment of the federal Constitution, then the states can also negate the 13th and 19th Amendments. Hey, I gotta say this, Mr. Chapman. All you gotta do is read Article 1 of the Commonwealth's Constitution. What Mr. Governor Northam is doing is null and void, including his goofball, douchebag, tyrannical voivodes. So, as it says here, there's what Mr. Smith had to say. We are the only country in the world that has a Second Amendment. Found one government in all of history that banned its own armed forces from keeping and bear arms. Found one government in the history of humanity that held the need to document a right for its armed forces to possess arms. Oppressive government always banned the people's right to arms. Claimed that the Founding Fathers wrote the Second Amendment to give our armed forces a right to keep and bear arms. Carry arms. Is S-T-U-P-I-D. Exactly. The only reason for the Second Amendment is to clearly spell out the God-given right of individuals to keep and bear arms. The only reason for the Bill list of rights was to codify individuals' God-given rights. Has there been a government that was not chock full of its rights up and including declared itself to be Lord God Almighty? Rome, Egypt, Israel, etc. Does the First Amendment mean government is allowed to give speeches? Try shutting up any politician, but they would love to shut you up. Hence the First Amendment. Anyone who tells you the Second Amendment applies to the Army or state militia is telling you they think you are stupid. There has never been a government that felt it had to codify its army's soldiers' right to keep and bear arms, because there has never been a government that refused to allow its own soldiers to keep and bear arms. The Second Amendment was written for the people, like the other 9 amendments in the Bill of Rights. This was confirmed by the Supreme Court of the United States in the D.C. versus Heller decision, where it stated that the people in the Second Amendment were the same people that were mentioned in the First and Fourth Amendments. Yeah, there's some controversy with that Heller case, so I don't really need to look at that. I always tell people this. I always recommend folks read the Federalist Papers, and I give you 4 on that. 2, 5 by Jay, 29 by Hamilton, and 46 by Madison. And we can look up 84, any Federalist Papers 84, by a pen name named Brutus, called Brutus. Okay, on lack of Bill of Rights on a federal level. So I'll just leave it at, but you can do your homework on it. Very interesting. But I will continue on here, where they stated that the people of the Second Amendment were the same people that are mentioned in the First and 14th Amendment. Fourth Amendment, excuse me. The Second Amendment clearly codifies the right of the people to keep and bear arms, and certainly not the militia. Why would a militia, a type of army manned by citizen soldiers as opposed to full-time regulars, need a constitutional amendment to guarantee that they have the right to keep and bear arms? Is there any specific statement anywhere in the Constitution that the Army Congress is empowered to has a right to keep and bear arms? Of course not. That is assumed. The Second Amendment specifies that the right to bear arms is the rights of the people, not the militia. It's the people who will make up the militia, but the right is not a right of a well-regulated militia. It is the right of the people. We, the people, were born with unalienable rights, meaning they come from God. The Bolshevik left insist there is no God, so they can deny your God-given rights. Well, it's interesting there's a lot of people who are agnostics and atheists, believe in natural rights as well. I know that for a fact. But one thing I know for sure, those treasonous douchebags in Virginia got another thing coming. It will blow back in their faces, for sure. And I do call it treasonous as well, according to the Code of Virginia, Virginia codes. Tells you all about it. But one of the areas I know, my friends, even if they have a Second Amendment, you got the 9th. And that's checkmate on a federal level too. And the 10th as well. But they want to terminate all that. They want it to be less active. But the bottom line is, Your rights can never be altered or abolished, but governments can. Lou Rockwell said that in the Mises Institute. So, I said to all my brothers and sisters up there in the Commonwealth, pursue the mission. Sun Tzu their rear ends. And if anyone in the National Guard is going to go by what the governor has to say, you go, no, I honor my oath of office, and you don't. And any other goofballs, including the Attorney General, treat them the same way. They're tyrants. No exceptions. Remember New Orleans, my friends. Treat them the same way. Garbage. Plain and simple. Alright, I'm going to do one more here. And this one here is mainly about the org, about the sale. ICANN needs to ask more questions about the sale of org. This is by the EFF, Electronic Frontier Foundation. Good site. I like it. And this is interesting because I see about the sales. This is what Mitch Stoltz has to say, Deep Link's blog. Over 21,000 people, 660 organizations, and now 6 members of Congress have asked ICANN, the organization that regulates the internet domain name system, to halt the $1.135 billion deal that would hand over PIR, the .org domain registry, to private equity. There are crucial reasons this sale is facing significant backlash from the nonprofit and NGO communities who make the .org domain their online home, and perhaps none of them are more concerning than the speed of the deal and the dangerous lack of transparency that accompanied it. Less than 3 months have passed from the announcement of the sale, which took the profit community by surprise, to the final weeks which ICANN, which is ICANN, is expected to make its decision, giving those affected almost no chance to have a voice, much less stop it. The process so far, including information that the buyer, Ethos Capital, provided to ICANN in late December, raises more questions than it answers. U.S. lawmakers are correct that the Ethos Capital takeover of the .org domain fails the public interest test in numerous ways. Before any change in who operates the .org registry can take place, ICANN, which oversees the domain name system, needs to answer important questions about the deal from those who use .org domain names as a foundation of their online identity. Working with the nonprofit community, we're asking ICANN to ask more questions to confirm how the deal will protect .org users. Or org. Questions that are still unanswered. Next week on January 24th, nonprofits and supporters will protest ICANN's headquarters in Los Angeles. You can join us to tell ICANN that must be more than a rubber stamp. Dangerous Deal, the Internet Society, or ISOC, which has controlled .org for the past 16 years, and Ethos Capital are treating the .org registry as an asset that can be bought and sold at will. But ISOC didn't pay to acquire the .org registry. Indeed, PIR, the organization that was founded by ISOC to run .org, was given $5 million to help it do so. Now the ISOC plans to profit off the value of the registry by converting PIR into for-profit LCC in the hands of Ethos Capitals. ICANN delegated the task of running .org to ISOC in 2002 because ISOC, I always get those backwards, good grief, was best positioned to run the domain for the benefit of nonprofit users. The excess funds from .org registration fees have supported the work of ISOC for the past 16 years, were a side benefit, not a sacred entitlement. Rather than asset like a building, the registry should be thought of as a public function. Like the assigning of street addresses, it should be and has been administered in the public interest. But in the hand of private equity, the registry will become something altogether different from what it has been in the past. A tool for making profit from nonprofits. After the sale, Ethno Capital, having paid $1.135 billion for .org to ISOC, will have to recoup that investment on a scale that's expected of a private equity firm. This week, Ethnos revealed for the first time that some $360 million for the purchase price will be financed with a loan. The payments on that loan will have to come out of the Ethnos profits. So they will probably need to raise money per year than ISOC currently does. While Ethnos could try to simply increase the number of its customers for .org's PIR, has tried this in the past, and the demand for the domains has remained largely flat. This is no surprise. The nonprofit sector just doesn't grow at exponential rates. That brings us to the myriad reasons nonprofits have criticized the deal. Every other way that Ethnos might increase profits is bad news for .org users. And these tactics aren't far-fetched. Every one of them is already delivering profits in other sectors, often while harming domain registrants and their visitors. Squeezing profits from nonprofit harms civil society. 1. The most obvious way to profit from the registry is for Ethnos to raise the annual registration fees on .org names. Under pressure, Ethnos has promised to keep fees increases to 10% per year on average. But they haven't made that promise legally binding. There won't be any way of .org users to challenge future fee increases without changing domain names. An expensive and risky process well known to any organization or which has had to shift away from a trusted domain. Even more worrisome, Ethnos could begin charging different rates for different domains. Other registries already charge considerably higher fees for names they designate as premiums. Ethnos could base fees entirely on an organization's ability to pay, essentially holding nonprofits' domains for ransom. 2. Ethnos could also engage in censorship for profit. As we've described before, other domain registries have made deals with powerful corporate interests like movie studios and pharmaceutical interests to suspend the domains of websites, even if that means suppressing truthful information. But .orgs don't just have corporate interests hoping to control their voices the world over, including within authoritarian regimes. .orgs are the home of important critical speech on the internet. Ethnos would have a clear incentive to take down domains at the request of repressive governments, just as governments often demand takedowns of speech on social networks in exchange for tax or other financial benefits. 3. Ethnos could sell the browsing data user who visit .org the operation of a domain registry can, if it chooses, track every lookup of an address within that domain. Ethnos could track visits to nonprofit organizations around the world, perhaps to target advertising on behalf of VidMob, the advertising company that they also own, including invading privacy of everyone who visits .org websites. 4. Ethos could cut back on the important technical upkeep of the domains. Domain name lookup must be available worldwide and quickly. Technical failures can mean being unable to connect to a website or to send and receive email. This doesn't just mean 404S, because the .org registry is a home to relief agencies, news medias, and other groups that provide life-saving services. Technical failures could result in actual harm. Aid might not reach people in need during a crisis. News and information could be stopped dead during an emergency. The .org registry has had no downtime in over a decade. If that changes, it is not just websites that would be in danger. Absolutely. Not enough safeguards. In response to public pressure, Ethos has made a loose commitment about future pricing, has also proposed adding text about acting in the public benefit into the certificate of formation. For the new holding company they're creating, and its promise to create a stewardship council to help guide the company's management. But there's no force behind these words. Under corporate law, only the company itself has the power to decide whether it's acting for the public benefit. Putting vague commitments into a certificate of formation doesn't give the users of .org domains any mechanism of enforcement, and a stewardship council will not be able to override the decisions of the company's owners and management. There is no guarantee that the council will even be informed about what the company is doing. In fact, PIR already has an advisory council and wasn't even told that the sale to Ethos was going to happen. Luckily, there are other options on the table. If the .org registry needs to change hands, ICANN must take the time to consider all the alternatives, such as a cooperative corporation of .org registrants, and determine which organization will best uphold the commitments that were made when .org was last reassigned in 2002. Instead of rushed and secretive vote, ICANN should engage in a careful decision-making process that gives all .org registrants a voice in decisions around the registry in the future. Interesting there. The benefits are vague at best. In defending the deal, ISOC's leadership has talked about the good they can do with the $1.1 billion endowment. Those good works, though, don't excuse breaking trust with thousands of nonprofits. Several proponents of the deal, echoing Ethos' talking points, claim that the turning .org into a for-profit registry will lead to new products and services for the .org community. No one explains what those would be, though, or what they have to do with it. Maintaining a reliable database of domain names, and there is no benefit at all if these vague opportunities in the future come at the cost of functional, censorship-free websites for millions of nonprofit associations and clubs around the world. ICANN needs to ask more questions. As a group that controls the top level of the domain name system, ICANN has the power to stop .org from changing hands in the name of a new organization to steward that important resource before the deal goes any further. ICANN needs to ask more questions of ISOC and Ethos. We've complied a handy list, and you can look at that yourselves. Anyone who's concerned about selling a public trust for a private profit can send a petition to #save.org, which will be presenting along with other nonprofit to ICANN in person next week. And if you be in the Los Angeles area on Friday, January 24th, come join us at the protest at ICANN's headquarters, organized by EFF, NTEN, and Fight for the Future. Help tell us ICANN.org is not for sale. And I have to respect that dearly. And another thing is good. One thing you can look at too. You should make another domain site for nonprofits as well. But areas I have to say, we don't want any technocratic society controlling the internet. It's happening with YouTube, Facebook, Twitter, the mainstream social media sites. We don't want to see this become more cancerous. So you got those two things. Support it on saying no to selling it to a big corporation, and start a new one. And I have to say that as well. Respect that. I can tell you this, in due time, we're going to have our own browsers, own internet system, the rate we're going. And we don't need these clowns. But I do say this. I do encourage people to go out there and support these sites that are under .org. And many of them are. Doesn't matter what they are, because they have the right to exist. They're not for profits. Because they could be punished. Because you got a bunch of technocratic oppressors out there. Love to manifest. So government and mega corporations, you got to always pay attention to. They like to work hand in hand, which is called fascism. I support free speech to the fullest. So you know what I gotta say? I say shoot it down. And I'm not trying to tell people what to do and anything like that, but I do see some controversies that can hurt every single one of us as well. So I say create a new site for nonprofits as well as an insurance policy. And that is it. I'd like to thank everyone for listening. Plus, feel free to download and share throughout your social media networks. If you have any questions, comments, or sense something interesting you want to check out, whatever you do, please send your correspondence with decorum. In addition, I will leave all my footnotes on the show on my speaker page. Once again, thank you for your time. Plus, always remember that demoniac resistance is helping for the soul and can liberate humanity. Until next time, take care of yourselves. Keep on spreading the love, and may your guardian spirits be with you.